over to Robert.
Thank you very much. I just also wanted to tell you, if you think that you've scratched your iPad, you haven't. We can't figure out what those squiggles are on there. We're going to figure that out later at some point in time, but certainly there was no reason to hold back on this to get that figured out. So I did want to tell you, I'm Robert Williams, and I want to really thank you for joining us today. And obviously, if you have questions later on, give us a holler. We're pretty happy to share and easy to share on these kinds of things. So yeah, it's now Fred. Now he's got the FSU background that he has, which is just, in my opinion, horrible. But I guess we'll just have to bear with that. So would definitely want to keep this light, but also give you some good information we expect. So next slide, Kelly.
All right, sorry, I'm clicking to the next slide, and there we go.
There you go. And see, and the squiggles are still there. So what I want to, this slide's obviously self-explanatory, but it kind of tells you what we're going to tell you, which is kind of the first rule of public speaking, I guess. And so the background, we're going to just kind of give you the quick and dirty on the background of where all of these requirements come from. But the topic today is enforcement of environmental laws in Florida, and we're going to focus on water-related issues. However, it is clear that many and most all of the enforcement actions and things that we'll be discussing apply to other areas as well. And so it's not to be necessarily exclusive, but just that's where we're focusing, because it's easy to cover that if we focus on one area, because there's always going to be those one-offs and loopholes, as lawyers would certainly call them, and exceptions. And so the one thing I did want to tell you is that as we go through these things, the DEP Enforcement Manual, and we'll talk about that in a moment a little deeper, is a great resource. It essentially gives you the DEP playbook. Next slide. So the background on all of these things is really found in Florida statutes, so Florida's Environmental Litigation Reform Act. And Fred's going to go into that quite a bit, but it really gives you the background, gives us the rubric and the background and the structure for providing the enforcement procedures for violations. Your clients probably already have or know they need a permit, but I did want to at least let you know that like sewage disposal facilities, that's covered in 403-086, and those are other rules as well. And then stationary sources of pollution that require a permit. That's really air and water. It's very expansive. That's over in 403.087. Discharges of waste into waters, and that statute at 403.088 also goes into if it causes exceedances of certain levels and those kinds of things. And then finally, obviously, the environmental resource permitting, the ERP, the statewide ERP, with those rules and the associated applicants' handbooks. What I wanted to just kind of show you right in this slide really was it's expansive, and we know that. I mean, everybody on this call, I think, understands that it's a very expansive list, but this is kind of, if you're looking for, when Fred and I were over at DEP and we were going through the pollution notification rule, one of the first questions that really popped up in that whole discussion was, okay, so what's, where's the basic authority for all of this stuff? Because we wanted to make sure we tied it back correctly, and here it is. Next slide. The definition of pollution in 403 is very expansive. It covers everything. And as you well know, 403 covers everything from water discharges, air, and it also goes into noise and all sorts of things in between. And then there are a bunch of other statutes that we'll talk about in a minute as it relates to a law change of where those things go in. But we're talking about pollution being very expansive. And so most of Florida's environmental regulatory requirements will tie directly back to this, and it's a catch-all. So if you ever want to say, well, I'm not, I don't fall within that, take a look at this definition. There are a few things that may not fall into that. Next slide. So when we're talking about enforcement, the first thing that we wanted to really discuss is the DEP guidance. And so the enforcement manual, which can be found online, and that's put together by the General Counsel's office, and it's updated regularly. And what that really instructs and gives the guidelines to DEP staff is how do they move forward with enforcement actions. And it covers everything from compliance assistance to notices of violations to short form consent orders, long form consent orders, when they're going to go to court and file an action on those types of things. And so it's really the long-term playbook for DEP, and it is a great source of information. So if you haven't had a chance to check that out and you're looking at enforcement action or just wondering about it, this is a really good place to start, and just as one of those tips. What they're designed to do, what they're designed to do, close Kelly, what they're designed to do is to actually give a lot of consistency within DEP for all of their actions, so that across the various districts in the state, that DEP staff is going to look through that, and you should be getting the same basic enforcement status and movement across the state. Now, that's never going to be perfect. It's never going to happen all the time. However, this kind of helps give them back to kind of the rules of the road. It's not an unadopted rule. It is guidance to agency staff. And so if we need to discuss that further, well, certainly we can, I'm sure, later on. But this should give us the rules of the road. Now, John Truitt, who's the Deputy Secretary for Regulatory Programs, issued a memorandum that is referenced in Directive 923. And 923 gives us some insight into decision making. His memo was specific to CAOs, or Compliance Assistance Offers. There has been, over time, in the last 10 years or so, kind of a shift and a focus from one I guess, theory of enforcement where it kind of pulled back a little bit. And the thinking on that clearly was that DEP is there to regulate and protect the environment, but as importantly with that, folks that are using permits and doing business need to be able to do their business. And so not every situation is going to result in a full-fledged enforcement matter. There are a lot of things that if they can be fixed immediately or quickly, or just aren't really a danger to the environment, and it's something relatively small, or even a paperwork type of a situation, that qualifies for a compliance assistance offer. And what that really means is that let's fix it. It's an easy fix. Don't really worry about it. Get it fixed, but it's not going to basically be a gig against your permit and result in a notice of violation or anything more serious beyond that. And so there's his memo, and you should definitely read it. It's fairly short, actually, but it limits compliance assistance offers to no more than 2 and a 5 year period. And if you want to get a third one, then you've got to go to Truitt and get approval for that. If you have a denial and you can't get that third compliance assistance offer, you can't get the first or second one, it's going to turn into a warning letter, a notice of violation, or a case report, which makes it go to court. And you guys can see that. And the quote in there, if the permittee corrects the violation in the presence of DEP personnel and the inspector doesn't deem the violation worthy of further enforcement action, then it may not even be considered a compliance assistance offer. And that's important because they put up a 2 strikes and you're out rule, basically. So I guess you already have 1 strike against you on that. The interesting part of this is when you have a written, DEP needs to track those typically. And so it's not going to be a quote warning letter, and it's not going to be a notice of violation. It's going to be a written compliance assistance offer. And they'll track those to make sure that they don't have a frequent flyer, I would presume is what they would call that. Next slide. So what the one purpose that we wanted to discuss with this group and everyone is the move towards additional enforcement action. And so is enforcement on the uptick? I can tell you that across our firm and also talking with other attorneys, across the state, there does seem to be an uptick in enforcement action on the part of DEP. And it shouldn't be very surprising. I think that, well, the most recent legislation, House Bill 1091, Senate Bill 712, which were both approved by the governor and effective July the 1st of this last summer, handled a lot of different things. I think it signifies the move towards additional enforcement actions being taken by DEP. And so 1091, I'll kind of outline a couple of things there for you. But House Bill 1091, it encourages counties, municipalities to set up inspection programs for privately owned lateral lines. Now that's for a sanitary sewage treatment system. So you'd have the trunk lines that go out, and then when it shunts off to the residents or the business, that line is going to be privately owned typically in almost all cases, I would expect. And it's clearly the inspection program they're putting in place is to stop stormwater intrusion into the system as well as leaks to the environment. And it also requires that if a owner of a piece of property, before they sell that property, knows of a violation or an issue with their lateral lines and leaks and those types of things, that's a must disclose situation. And so it's a known issue that they have to disclose. And so they're putting some teeth into that, into that situation there. And so there's also going to be, along with that inspection, there's going to be a publicly available database that folks will be able to look at it and get to. And so there is going to be a lot more teeth into this, and that's worth noting. The biggest thing that this bill does, that last slide, yeah, House Bill 1091, the biggest thing this slide actually does is increases fines for almost everything DEP regulates. And I mean almost everything. And so I'm not going to hit you with everything in the world, but we're talking beaches and shores, increased penalties from 10,000 to 15,000 maximum penalty. Biscayne Bay Aquatic Preserve, all aquatic preserves, moved some civil penalties up from $500 to $750 a day, and a maximum civil penalty increased maximum from $5,000 to $7,500. Water management districts have their civil penalties increased from $10,000 to $15,000, and that includes artesian wells. They have their own per day increase, management of storage waters, and those kinds of prohibitions. Coastal waters and lands, which include terminal facilities, vessels, enforcement and penalties otherwise on the coastal lands, that got moved up a maximum penalty from $50,000 to $75,000 total. There also is a provision there with gambling vessels, energy resources, land reclamation, and all of those fines moved up differently. It's not a set move up, but it seems to be either doubling or a third higher. Or 50% more, and it's in that kind of range. The DEP enforcement procedures, which Fred's going to talk about, I think, quite a bit, 403.121, DEP can now proceed administratively and get a fine if those penalties don't exceed $50,000, and that's up from $10,000. So that's a huge increase. And so what that does, it may help the regulated businesses in that they can still move administratively, but there's going to be a lot more teeth, but they won't get pulled into circuit court. And so that is as well worth noting. Civil liability has moved up as well. Criminal liability is a second degree misdemeanor with potential fines. That moved up from $5,000 to $10,000. And if you look at the general law on misdemeanors, a second degree misdemeanor does not carry a $5,000 fine. That's reserved typically for third degree felonies. And so the teeth that they've put into this, litter law, that went up. Small quantity generators, that went up. Abatement caused by hazardous substances, those fines went up. Hazardous waste generators, coral reef protection, derelict vessels, you get the idea. It is a broad brush on everything that is requiring increased penalties available. Senate Bill 712, moving to that one, and yeah, I'm only off after the first one right now, but moving to that one, it moves the moved the regulation of septic systems, on-site sewage systems, from the Department of Health to DEP. And that was something that was a clear push by DEP to acquire. And that is really focused and tied quite a bit to the basin management action plans that DEP has across the state that the legislature required. And so an issue with the basin management action plans were all of the, in a lot of those areas for springs protection, for surface and groundwater protections and those kinds of things. But the issue was septic systems, or how well were they working? DEP will now follow up, I expect, with the enhanced septic system treatment programs to pull out more nitrogen and those kinds of things. So expect those to be coming down the road as well. The other item that this actually handles or does in Senate Bill 712 that's of note is that it requires the Florida Department of Agricultural and Consumer Services, the Department of Ag, to go out and inspect more often, requires them to inspect the best management practices employed by ag producers and ag properties in specific basin management action plan areas. And so that is also a signal that if you look more and you inspect more, you're going to find more. And so, you know, it's like a law enforcement officer on the side of the highway. If you don't have your radar gun turned on, you're not going to find out whether they're speeding or not. Next slide. That leads us to inspections. So this is the first step, obviously. So typically, you know, the agency has a right to inspect. So if you don't believe that, read your permit conditions. It's going to have all kinds of stuff in there saying that they have the right to inspect. Additionally, those inspections they also have statutory authority. And so if you don't allow folks on the property, then they're be able to go get a warrant potentially. I've been involved in a couple of those situations in the private sector, and they're not fun. When law enforcement shows up, and we'll talk about that in a minute, when law enforcement shows up with a warrant and you don't have a choice, they're coming on. And so you have an obligation under your permit to allow certain inspections. And so really, what do you do to make sure you stay safe when you're doing that? So what to expect? So first of all, it makes sense to, before those inspectors arrive, let's have your own pre-inspection. I mean, if you know you've got an inspection coming up or one's going to be due, kind of get out there and take a look around and make sure that you don't have anything that's major that needs to be fixed. And if you do have major things that can't be fixed immediately and those types of things, I'm not saying about covering them up, and never, ever, ever, ever lie about stuff and never give false information to the state. But at least then you have the opportunity to have a plan of action to help mitigate those types of things if it can't be taken care of. So have your safety meeting if it's appropriate. If they're coming into a big plant and you need to have that, do that with those inspectors to make sure everybody is safe. Make sure that the information that's required by the permit is available and accessible. And most of all, really use your common sense. Don't go out of your way to start pointing out violations they might not pick up on. Get those fixed if they're not noted, obviously, but you don't have to necessarily, bare your neck to them. Because you've already done that. You've already sent them all of the reporting requirements typically. And if there's going to be exceedances of allowable discharges, those are going to be covered in that. So remember, finally, that you keep good records and take advantage of those compliance assistance offers when they come up. Finally, before I turn this over to Nicole, who is a much better speaker than I am anyway, remember that DEP now has law enforcement officers. So 10 or 15 years ago, all of the law enforcement officers in the Environmental Crimes Unit were shipped over to FWC, Florida Wildlife Commission. They're back. Last year in 2019, the Environmental Crimes Unit, which is 18 law enforcement officers led by a captain, were transferred back to DEP from FWC. They're led by, that office there is led by Mary Alice McElhenney. I don't know if I'm saying that correctly, Fred, you can correct me, I'm sure you will. She's a super nice lady, very talented, very bright. She's not a sworn law enforcement officer unless something's changed since I spoke with her last. but they can and will get warrants if they absolutely necessarily have to. So with that, and I look forward to any questions you might have at the end, I will happily turn this over to Nicole.
Thank you, Robert. So FDEP has a number of mechanisms to encourage compliance with their environmental rules and regulations and to address issues of non-compliance. And Robert touched on a few of these when he discussed the Truitt memo. But once an inspection has been conducted and DEP takes note of a violation, one of these four options may be used by the department as an initial response to the violation. And those are compliance assistance offers, a warning notice, a notice of violation, or a case report to the Office of General Counsel. With respect to compliance assistance offers, and as Robert mentioned with the Truitt memo, the policy has been shifted a little bit in recent years on this, but they're normally used when there is a minor violation and the department does not intend to pursue a consent order or other penalties if the violation is promptly corrected. Now, if the violation is not corrected, of course, the next step is to issue a warning notice. And these warning notices are normally used if they initiate with a warning notice. That's traditionally used where the department does intend to pursue a consent order of some sort and to issue some possible penalties. The warning notice typically begins the formal administrative process, although it is not set forth by statute. And it's used as a method to investigate the violations and, give a voice and initiate some sort of settlement agreement without having to go through the more formal process that is notice of violation, which is similar to a judicial complaint, and there's specific requirements that the department has to include in there. There has to be a finding of fact that there was a violation, some sort of conclusion of law with respect to what statutes and regulations or regulations are being violated, and then also provide a mechanism for corrective action and give respondents a notice of their rights. And Fred will get into this more, but potential for an administrative hearing and the timeframes for that. Now, the options after receiving a notice of violation, there's very specific time parameters in there that you need to pay attention to if you ever receive one of these things, because if you fail to respond within 20 days, a default final order will be entered. That's, you want to respond to those and contact your attorney if you receive a notice of violation. Then the other possible option that DEP may pursue is by filing some kind of a case report to the Office of General Counsel. And typically these case reports are used where staff is making a recommendation to move up to the judicial process. And so with that, it might be a recommendation to have the Office of General Counsel look into whether or not the seeking of a temporary injunction is required. And traditionally, this should only be used or will only be used if the responsible party refuses to cease an ongoing violation after, either a warning notice or a notice of violation. And the ongoing violation involves a potential health threat or potential significant harm to the environment. And the case report option is always available to the department at any point in the process. Next slide, please, Kelly. So I mentioned briefly about consent orders. So the formal administrative process is typically initiated by serving a notice of violation and is finalized through the entry of a consent order or final order But a consent order may be entered into at any time in the process, whether that's, prior to the warning letter coming out, after the warning letter, before the notice of violation, or not. And a consent order is a legal document that binds the respondent to perform certain acts and is authorized by the Administrative Procedure Act. As I mentioned, it can be entered into at any stage of the administrative process. And it sets forth the terms of a settlement between the department and the respondent. And the department uses 3 types of consent orders, depending on the nature and stage of the violation. And those are the short form, the long form, and the model. And before a consent order could be issued, and they must contain a finding by the department that the respondent has violated an environmental rule or regulation. So the short form consent order is used in cases where the only major issue is the payment of monies, either for penalties. So there's an agreement between the parties that there is violation, a penalty should be assessed, and that's when short form consent order can be used, and that doesn't need to be reviewed by the Office of General Counsel. And it can contain an option in there for making payments over time. Now, the model consent order varies program to program, and they're pre-approved orders as well. There's a set of instructions that is available for how staff can apply and use the model consent order. And that leads us to the long form consent order, which is used in the more complicated cases where there's more factual findings, really everything else. So if it's not appropriate to use the model or the short form, they'll use a long form. And like the notice of violation, the long form consent order has specific requirements that must be included in there, including all of the findings of fact and conclusions of law that the department has reached. Again, orders for corrective action and a notice of rights that you can move out of, the administrative process or not necessarily out of the administrative process, but out of this process and into the next phases of the administrative process. And so that's some information on consent orders. Final orders, of course, occur where after the issue's been resolved, it's gone through the administrative process, the department will issue a final order. And then there are some other informal, they can occur during the informal process or after the formal process has begun. And again, it's done in order to reach some kind of a settlement agreement before having the parties, the department and the alleged responsible parties move through the administrative process, the expensive portions of the administrative process. And those are informal conferences wherein, if you've been issued a warning letter or you've been issued something by the department, they appear to be amenable to discussions in order to get the issues resolved. And also mediation is available really at any time, even before you're in litigation, administrative litigation. Mediation is an option that's available in order to reach some kind of a settlement with the department. And with that, I'm going to turn it over to our last speaker, Mr. Frederick Aschauer.
Wow, Mr. Frederick Aschauer, thank you very much, Nicole. So if you knew me when I was at the department and you knew me at the time I left the department, you know that I left because I wasn't doing litigation. And to me, I enjoy litigation. It's something that I've done my entire practice, and in the positions I held at the agency, I wasn't doing any of that. So I really wanted to get back into the private practice and represent people in litigation, particularly environmental litigation. Now that means permit challenges, but since I left, that also means enforcement actions. And Robert indicated that there was an uptick in enforcement. There is no doubt been an uptick in enforcement, but not only in the number of actions that are coming out of the agency, and here I'm specifically talking about DEP, but the stance of the agency. The agency over the last couple of years has become much more aggressive with its enforcement, and the penalties that they're seeking to assess have increased. At least when I first started handling enforcement matters in this firm, some of the numbers that were coming out of the agency were surprising to me based upon my experience when I was with the agency before. So it's an uptick in the number, and it's an uptick in the fees that they're attempting to assess. And before I go to the next slide, one thing I do want to say is our focus here is on civil proceedings or administrative proceedings. As Robert talked about earlier, the department has an enforcement group now. They have sworn law enforcement officers who can come and arrest you. Just the other day, they arrested a man in Brooksville for violations of environmental law. So that is out there. If you get the handcuffs slapped upon you, you need to get a criminal defense attorney. So hopefully that won't happen to anybody who's listening, watching our, our Lunch and Learn. But if you do, then you need to go get a criminal defense attorney. That's what they do. We have been called in to help explain environmental regulation and things like that. But in that realm, you really want somebody who's got a criminal defense background. So next slide, please. So we're going to talk about this through the lens of the Department of Environmental Protection. So what does it look like from their perspective? I am ignoring the water management districts, but I'm doing so purposefully. Water management districts, of course, have their own authority to enforce in 373, but theirs is limited. They have a limited authority as compared to DEP. And so we're going to talk about LRR, which is the Environmental Litigation Reform Act. We're going to talk about how that process is through both civil and administrative proceedings, but we're going to do so through the department's lens. Now, I have some thoughts and some theories on why the water management district is limited in its authority, and has some legal opinions on the limitations of the water management district and their authorities to take action. But if you want to hear those, you either need to tune in to the future Lunch and Learn that we do on water management district enforcement, if we do such a thing, or if you find yourself on the receiving end of an enforcement action from a water management district, get us under a retainer agreement, and then I'm happy to tell you about my theories on their legal limitations. I'm also not going to talk about federal criminal or federal enforcement of environmental laws, and we're not going to talk about citizen suits. So this is really about how the Department of Environmental Protection proceeds, because at the end of the day, remember, whatever the water management districts can do, DEP can do. And so really they are the umbrella agency for protecting Florida's air, land, and water. So first things first, the department has the right to bring a civil action under 403-121, subparagraph 1. The way I like to think about this provision in the statute as compared to the other provision, which we'll talk about on the next slide, which is administrative, is this is the provision where if they're looking to come after you strictly for money, this is one way that they can do it. If they're looking to come after you and make you do something, they do that in the other way, in the administrative proceeding. So a civil proceeding is filed if the DEP is looking to establish liability or recover for damages. It begins with the filing of a complaint in a court throughout the state. It would be in the local jurisdiction wherever the action took place. It's before a circuit court judge. You respond via an answer, and it's governed by the Florida rules of civil procedure. And so that's the traditional court system that people outside of our world know and understand. Many people don't understand the administrative process before the Division of Administrative Hearings. They are familiar with this because this is the same court that has family law, has criminal law, has your personal injury. So these judges are those judges. And so it's important that DEP has this authority, however, because if they go under an administrative complaint and they take you to DOA, if they get money, a judgment of money against you or an order where you have to pay, they have to go to circuit court to enforce that. I do want to touch on one thing. Robert mentioned that in 403-121, they have the department has the ability to seek fees or civil penalties or administrative penalties. And he dropped some numbers on you: $50,000 for administrative, $15,000 here for civil. That is, however, that is on a per violation, per day basis. Now, many of you may already know that, but that's something to keep in mind. So if your client, for instance, has a facility where there is a release, we'll use the hazardous waste world, where they have a release from some part of their process. It may be through some filtration system or something along those lines. They have a release, and that results in material getting on the ground, and that material is covered as a hazardous material or a material that needs to be cleaned up and remediated under the statute. They can assess you for every day it's on the ground. And so it adds up quickly. Let's go to the next slide, please. So the administrative proceedings are commenced under the same statute under ELRA in subparagraph 2. It begins with an administrative complaint. There must be a notice of violation, which Nicole talked about. That notice of violation that she talked about has to tell you what you did wrong and has to propose how you remedy it. You have to respond to the administrative complaint, and you have to respond to a complaint in circuit court either. If you fail to respond to either one of those, you will find yourself on the receiving end of an order that finds you have done exactly what they said, and they're going to assess the violation. They're going to assess whatever damages they have claimed against you, and they're going to take some type of action, and it could result in loss of license or penalties, etc. So if you fail, or your clients, in most cases I believe it'll be your clients given whom we have on this webinar, if your clients fail to respond to either one of those documents, they will get a default judgment, in essence, entered against them. And that will mean the agency has full authority to take action against them, get those fines, etc., because in essence, you're basically pleading guilty if you fail to acknowledge it. This administrative action is before the Division of Administrative Hearings. That means it's heard by an administrative law judge. If the department does not seek administrative penalties, then it retains its final order authority. However, if the department is seeking administrative penalties, then the administrative law judge has final order authority. And that's important because if the agency has final order authority and they disagree with the administrative law judge on a point of law, they can simply issue a final order that goes in how they see the statute or rule they're interpreting. There is a process. There's a process that is spelled out when you're served. It tells you how to respond in circuit court when you're served with an administrative complaint. It tells you how to respond to. There's an election of rights form. You return that, and you return your response as well. This proceeding is governed by our uniform rules. Those uniform rules are laid out in Chapter 28 of the Florida Administrative Code, and they're what govern whenever you're at the Division of Administrative Hearings. Those are the rules that govern. So if you've been involved in a permit action, it'd be the very same rules that are involved. I will say that both processes are designed to give you your opportunity to have your day in court. So even though I have warned against failing to respond, if you don't respond, you'll get basically found guilty. But if you do respond, the system's really designed to give you a full and fair hearing. So once you participate, you can get yourself going on the road to having your day in court. Next slide, please. All right, so just some general principles. First and foremost, an enforcement action is penal in nature, and that means that it is akin to a criminal violation. And like a criminal violation, you or your clients have to be very clear on what exactly you did wrong. The agency needs to spell out and inform you what you did wrong. They cannot surprise you at hearing. They have to allege it. They have to tell you what you did. They have to cite to the rule. And so they have to first very clearly spell out what you did wrong in their complaint. Then as you go forward in the hearing or in the trial, the burden is on the agency. So they have to prove. Now, it's not beyond a reasonable doubt. It's what we call a preponderance of the evidence. So that means a lot of the evidence stacks up in their favor, if you want to state it simply. They have to prove that you did the action. Unlike a permit where you have to prove your entitlement to the permit, you have to demonstrate your reasonable assurance. You have to overcome the objections of whoever has challenged your permit. In this case, the agency has to prove their position. And so that's important to keep in mind. You'll be in the defensive posture, and you'll be just trying to prove that they didn't prove their case. Like a permit challenge, experts are still critical. So you are still going to need to be, and if you are a consultant on this, you're still going to be involved just like you would a permit challenge. But in this case, you'll be rendering testimony as to whether or not you think something is or isn't a hazardous substance, whether or not something was a best practice. And so you still will be opining and offering expert opinions. It's just in a different sense. You're looking back instead of looking forward like you would in a permit challenge. As compared to a permit challenge where you're trying to demonstrate what will happen in the future. Will your permit do what you say in terms of its ability to ensure that you're not going to cause harm? In a enforcement action, the facts, what happened, is very important. So factual testimony is very important. And so one thing that I would encourage you all as consultants, if your clients come to you and they have an issue, you really should get a lawyer involved quickly. I'm not saying it has to be us. Obviously, I feel like our firm is very well suited to handle all enforcement actions that are before the Department of Environmental Protection. But if it's not us, get a lawyer involved. And one of the reasons you want to do that is we can start to assess and assemble that case, and we can do so under certain protections that would be available to the client, like attorney-client and work product. If you start to assemble things without the direction of attorney, you may very well provide the department their roadmap to find your client did exactly what they're saying they did. So this is an area where, unlike the permit challenge, it really needs to be driven by attorneys, and so you need to get an attorney involved right away so we can assemble the facts and start really helping with describing the narrative. Next slide, please. So just some general ideas. If you're involved in permit challenges, you know that the department issues what we call a 70-day order. Here, with an administrative proceeding, and that is you get an order and you have to go to final hearing within 180 days unless the parties agree to a later date. So if your client is interested in getting this matter taken care of, getting it over with, you have maybe some business reasons why you need to get resolution, and you're not willing to settle, and you're not willing to go through a consent order or something like what Nicole talked about, and you really want your day in court, you can compel resolution of this within 180 days. Of course, the parties can agree to a longer time period. That's an administrative proceeding. In circuit court, there isn't such a deadline. That is only an administrative. So there, you're subject to a myriad of different things that can happen in civil proceedings. And as a lawyer who handles both circuit court matters and administrative matters, I can tell you that circuit court matters tend to last longer. They tend to get developed slower. And so you might find yourself, if you're involved in a civil proceeding, having that dragged out significantly longer than an administrative proceeding. The statute specifically provides that the prevailing party gets costs, which means your costs for depositions and other things that are chargeable. And it also allows the attorney's fees to the licensee or the respondent, the party who is subject of the administrative complaint, if there's a finding that the notice of violation was not substantially justified. So these are some things to keep in mind. Next slide. Okay, these next two slides cover what DEP calls good faith in DEP 923, which Robert talked about earlier. That's the DEP's guidance on enforcement. And it's what I call mitigation because ALJ or a circuit judge can hear evidence in mitigation, and we'll talk about that in the case review in a minute. And so in my experience, there are a number of things you want to do if you are subject to an NOV or you're subject to an administrative complaint. And the first and foremost thing you want to do is you want to establish that your client has done certain things to mitigate. One of those things, not expressly laid out in DEP's good faith efforts to comply, but something you absolutely want to do, and we have experienced or it has been received well by the agencies when we represented clients, is you want to engage proactively with the agency before a notice of violation is issued. If you have something at your facility, your client has something happen at their facility that's a violation of the DEP's rules, more than likely, pursuant to your permit, you have a reporting obligation already. Either way, you want to make the agency aware of it, and you want to make them aware of what you're doing to remedy it, and you want to do that quickly. And so you want the agency to know you take it serious, or your client takes it serious, and what they're doing to fix it. That is critical in my experience. So mitigate. That's what you need to keep in mind. And here, I'm not talking about purchasing credits at a mitigation bank pursuant to a UMAM analysis. I'm talking about establishing facts that will show either good faith or will show that your client took reasonable steps, or show that your client really just misinterpreted but had a good faith reading of the regulations but just misinterpreted it. And so you want to make all these efforts to show the agency that what wasn't happening is that your client was fully aware of the regulations, that they purposefully avoided those regulations, that they were aware of the harm that could be caused by ignoring those regulations. Because if those facts stack up, and that's how you find yourself, and your client did those things, then DEP 923 actually provides for them to accelerate the fees against you. If you are knowingly doing these things, that's really bad, and they're going to bring the hammer, and that's actually how you get into the criminal realm, when you purposely avoid the statutes for economic gain or convenience or something along those lines. So I'm not going to read all of them to you, but these are the good faith efforts. Actually, while we've been going, some folks have texted me and asked about how you can get this. We post this presentation like we do all of our presentations. We will post it to our website. So these are a few. While I've been talking, I'm sure you've read them. So you try to train your folks. You show that it was just a misinterpretation, but it's a legitimate misinterpretation, and that you've been making reasonable efforts to try and come into compliance. Next slide. So what I talked about earlier, this is D. Like I said, doesn't expressly say it, but the responsible party took action on its own to mitigate the violation once it discovered that violation. Of all the good faith efforts, this one is, in my opinion, based upon my experience, and again, I've been handling a significant amount of enforcement action since I left the agency. And as general counsel, both Robert and I were responsible for the prosecution of every enforcement action while we were there. This is beyond a shadow of a doubt the most important. Yep, it happened, but here's what we've done to fix it. So next one is sort of in line. They got go back. Yeah. So the next bullet point is a kissing cousin, if you will, to the bullet point immediately above it. That, look, we made these changes, we've done these things. You want to demonstrate that you recognize what happened and you have absolutely proactively addressed it. Let's go to the next slide. So a couple cases, I've only got 3 of them, and I know we're running up on our time, so we want to leave the opportunity for you all to ask questions. So going back to the agency has the burden This case, Gardenia versus Florida Department of Pollution Control, which shows you how far it goes back, stands for the proposition that the statute must be construed in favor of the regulated. So your clients get the benefit of the doubt. If there is a discrepancy, they're going to get the benefit of the doubt because, again, this is like a criminal statute, and therefore so that it basically comes down to due process requires that you get the benefit of the doubt, because you have to, if you're going to punish somebody under American law, you have to be very clear in what they're being punished for, and that's why you get the benefit of the doubt. The next one is interesting. The department, and in fact, in the cleanup world, the department has certain provisions that make concessions if you can't afford to do cleanup. That having been said, don't ever tell your client your inability to pay is absolutely a waiver of their responsibility to conduct remediation, because this ZK Mark case does not support that. If you're telling your clients, hey, if you don't have the money, you're good, pragmatically, that may be true. The agency may be willing to entertain it. There may be programs that can get them money. They can get into programs to get cleanup. However, I'm telling you that under this case, your client's inability to pay for remediation is not a factor to be considered by the agency. Next slide. And we've talked about this. So mitigation. A circuit court judge can also hear evidence in mitigation. An administrative law judge can hear evidence in mitigation. And an administrative law judge pursuant to statute can reduce the penalties by up to 50%. The agency will suggest what those penalties are when you start. So one way to chop that in half is present a good case on mitigation. And the authority for you to do that is in this case, which is DEP versus Holmes Dirt, but it's also expressly laid out in the statute. So some cases to sort of highlight some principles that you want to think about. In the end, remember, if your client's been served with a notice of violation, you have, beyond a shadow of a doubt, entered into the lawyer's world, and you really need to direct your client to engage with an attorney. Because if they don't act to protect their interests when that case is initiated, they could very well find themselves on the receiving end of an order that makes them do something for an action that they may not think they're responsible for. So I think that's my last slide. We can go to the next slide. So of course, you have the three of us, your presenters. For those of you that texted, yes, I do apologize that we included Robert in this presentation, but we'll try to make sure we cut him out of the next one. So, and that's for his comment about my previous background, but the new one probably reflects my personality as well. Kelly, do we have any questions?
I do not see any questions right now in the chat feature of Zoom, but I just wanted to remind everybody that if you think of any questions later today or next week, definitely feel free to reach out to us. An easy email address to remember is info@llw-law.com. And of course, we put the email addresses and phone numbers up here in this slide if you wanted to take a quick screenshot of it. Of course, everybody's contact information is on our website at llw-law.com. And of course, I just wanted to make a plug that if you wanted to hear about future lunch and learns or just hear about, firm updates, you can, connect with us on LinkedIn. You can follow us on Twitter, Facebook, and you can sign up for our emails. I'm going to check the chat really quick because I think we have seen a few. Oh, we're just no questions, just some comments about thank you for the great information. Thank you to LLW for this very helpful webinar. Thank you very much for that. That's great feedback. I wanted to thank Robert, Fred, Nicole. Thank you so much for your time today and the great presentation. And I wanted to thank each of you. We will be sending around a recording, an email with a link to this recording. So be on the lookout for that. And if there are no other questions, this concludes the presentation right at 12:57. I don't see any more questions in the chat function. So I think we're good. Well, let me see here. I'm
Well,
just
for-
getting all sorts of thank yous.
For
So
Robert's benefit, would you mind reading Elva Pepper's comment? And I know you'll like it.
I'll read the one that I got, that my info is the best, and that she really appreciated. That wasn't from Elva, because Elva's, she has her own problems. So.
well, I'll read it because I'm a Knoll. So go. And I'm the moderator, so I can mute all of these other folks that are hating on FSU.
Hey,
So.
I've been kicked off Zoom by meaner people than you, so pretty much everybody.
All right, well, I'm still not seeing any questions coming through the chat function. So again, just remember, you can always email us at info@llw-law.com. And presenters, if you have anything else, otherwise I hope everybody has a great day and a great weekend.
Go Gators.
Thank you, everyone. Thank you, everyone, for listening to Robert today. We know we tested your patience in that regard.
Yes, thank you very much.
Everybody,
Thanks, bye-bye.
presentation.